Thank you very much, and good afternoon. I really applaud all of you for being here and having an interest in this very important topic. I thought I'd just start by trying to talk about my first experience with the death penalty in Ohio. When you run for governor, it's not something you think about a lot. I don't know if any governor would have that even in their campaign platform or their campaign agenda, but you don't realize before you take office that you're going to be spending a lot of time as a governor in a state with a death penalty in particular, reviewing requests for clemency. And in fact, in the governor's office, if any of you are students aspiring to work as a staff attorney in the governor's office, we had, one staff attorney did almost nothing but review requests for clemency that came in, not just on death penalty cases, but on other cases as well. In Ohio, I became governor in 1999, and the first case came to me for a clemency decision just 2 months into my first term. And that would be the first execution in Ohio for 36 years, because Ohio's death penalty had twice been declared unconstitutional. A statute had been reinstated in 1981, and it took that long for these cases to wind their way through the state appeals process and the federal appeals process. So the first case that came to me was in 1999. The defendant's name was Wilford Berry. He was described as a volunteer because he stated he was ready to die for his crime, and he had waived a lot of his further appeal rights. He could have extended his case out a very long time. There didn't seem to be any basis for granting clemency. The Ohio Parole Board, which is in Ohio, is the first step before you get to the governor. Has to review on that. They recommended against granting clemency when it came to me. I did not grant clemency, but because it was this unique case, the first case, and also because he was waiving his rights, you had to make sure that in fact he was doing that. And perhaps I should have gone myself to visit him, but I sent my chief legal counsel to the prison where he was being held to interview him and to make absolutely certain that he was comfortable about waiving his further appeal rights. And then what I didn't realize at all is that whenever an execution occurred, I wouldn't have to be there in person, but I would almost have to be present telephonically, because the director of the Department of Corrections, who was responsible for the execution, he would be present and he would be overseeing it. And if, for example, Wilford Berry at the last minute had decided to not waive his appeal rights, that changed his mind and didn't want to die and was prepared to pursue further appeals, then I would have had to have instantaneously granted a reprieve to him or a delay. So I'm sitting there, waiting for the phone call from the prison where the execution would occur. Each time, maybe 15 minutes before the execution, I would get a phone call, and then about 10 minutes after the execution, I would get a phone call. But sitting there, it was in the evening, and making that decision, and just hearing the case about Wilford Berry, and then, of course, he was executed. It occurred to me that that the state of Ohio, I mean, it's obvious, but I felt it, was terminating the life of a human being. And yes, it was pursuant to law, but obviously that sentence is irrevocable, and you sure don't want to make any kind of a mistake, a mistake of fact or a mistake of law. You want to make sure that all of the convicted person's rights have been upheld. And so I spent an enormous amount of time as governor, reviewing clemencies, and clemency would be asked for in every single death penalty case. And while I was governor, there were 26 cases where clemency was requested, but I spent, there was a write-up that came to me, but I spent a lot of time poring over those because, as I said, you certainly don't want to make a mistake. In only one case, I felt clemency was an extraordinary remedy. And as these cases had, generally they came to me having gone through innumerable appeals at the state level and the federal level, all the way through habeas corpus. And so a lot of scrutiny. There was one case, however, in which I did commute the death sentence to life imprisonment. And that case is an example of how technology has changed the death penalty procedure significantly, because in that case, it was the case of Jerome Campbell, and subsequent to conviction and while he was in prison, there was a request that was upheld for additional DNA tests. DNA tests had not been available at the time that that Jerome Campbell was convicted. But so additional DNA tests were done on some blood that was on the shoes of the defendant. And the prosecutor had relied on that blood a lot at the trial level. But DNA determined that the blood on the shoes did not match the blood of the victim in that case. So this did not exonerate him, but I felt very strongly that had this evidence been available at trial, that the death penalty itself might not have been imposed in that case. So there was enough doubt for me to feel strongly that the case should be commuted to life in prison. So that's just a kind of an example of how I approached it. I think later on we can talk more about some reflections and, in terms of dealing with these cases and how I felt about it, but maybe we should move on to Mark right now.